Hello and welcome to this web presentation on premises liability and specifically the special considerations for landlords. My name is Ken Horges and I'm an attorney here at Seacrest Wardle. I've been defending premises cases for many years, so I'm glad to be presenting today on this topic. A few things that you'll see there on the first slide that apply to all premises claims is that ownership and legal title are not dispositive. And what is key is actual possession of the property and exercise control of the property. So ownership is really all that counts for liability for the landlord, that is the property owner. If you own the property, then generally you can be held liable. But the entity that has control over the property or possession of the property also has duties that can be liable, and so they can be liable also. And this comes into play, for example, if a management company runs the operation or has control of the property, or if a business is renting your property, those entities with control over the property and possession can also be found liable. So the bottom line here is that ownership, possession, and exercise of control translates into potential liability. Before we get into some of the more substantive concepts and rules, there are some areas of a premises, of the property, that might look like a landlord has possession and control of, but maybe actually does not. And a couple of those areas are grassy areas between sidewalks and streets, berms, or sometimes called parkways. If the city or a municipality, it's usually a city, has an easement over that portion of the property, then the landlord does not possess control of that area of the premises. And so the landlord would not have a duty with regard to that area. And the same rule, by the way, applies to driveway approaches. Sometimes they're referred to as driveway cuts. Same rule would apply. Here we get into some more substantive material that's really specific to landlords. The Landlord Tenant Act, and you see the citation there. It's at MCL 554.139. The Landlord Tenant Act, I'm going to be talking a lot about that. The Landlord Tenant Act sets out statutory duties for landlords. And those are essentially three. One, a landlord has to keep the premises and all common areas fit for the use intended by the parties. Second thing is the landlord has a statutory duty to keep the premises in reasonable repair during the term of the lease. And three, a landlord has a statutory duty to comply with applicable health and safety laws and regulations of the state and local governments, so cities, counties, other municipalities. These are the duties that are set out by the legislature, and that's important when it comes to defending premises liability claims. And one of the reasons that it's important is seen here on this next slide. The open and obvious doctrine, and we're going to be talking about that in just a moment, but the open and obvious doctrine cannot be used to avoid specific statutory duties. So when we go back and look at the statutory duties under the Landlord Tenant Act, these duties are in place, they're statutory, and the open and obvious doctrine will not be available in the context of those statutory duties. Now, we hear a lot about the open and obvious doctrine, and we rely on it to a great degree in defending premises claims. But the open and obvious doctrine, that defense, does not apply to a landlord's duty to keep the premises in reasonable repair or to keep the premises and the common areas fit for the intended use, or the landlord's duty to comply with state and local ordinances having to do with health and safety. So just to say this again, the open and obvious doctrine does not apply as a defense to these statutory duties. And the last point you see there in the slide relates to situations where a plaintiff, for whatever reason, an injured person, for whatever reason, does not prove a breach of a statutory duty. And in that case, the open and obvious doctrine would apply. And just as an example, if a plaintiff can't show that there's a lease agreement, for example, then there's no statutory duty, and the open and obvious doctrine, that defense could potentially apply. Now, as with all things in the law, there are exceptions to the open and obvious doctrine, that defense. Lawyers build their career dealing with exceptions. The statutory duties of the Landlord Tenant Act do not apply to a lessee's social guests, and so the open and obvious doctrine would apply in that circumstance. So if a tenant invites a person, just as an example, over for dinner, the statutory duties do not apply to the dinner guest, so the open and obvious doctrine would be available. Again, we're going to talk about the open and obvious doctrine and everything that goes into that, but just for this purpose, the open and obvious doctrine would not apply to a tenant's social guest. The landlord does not owe statutory duties related to fixtures on the property. That's called the fixtures exception. And a landlord must have actual notice of an alleged defect in order for the statutory duty to apply. Now, shifting gears here, this slide is called Common Law and Snow and Ice. We're going to be talking about both things here. Michigan has some pretty nasty winters. We're not the only state that has harsh winters, that's for sure, but we get lots of snow and ice. Michigan common law, now that's not the statutory law we've been talking about, but common law provides in general that snow and ice on the ground is an open and obvious condition. And you see there this thing called indicia of potential hazardous condition for purposes of open and obvious. Those indicia of potentially hazardous conditions, or maybe markers of a potentially hazardous condition that would be visible, is if it is snowing or has recently snowed heavily, if there's been freezing temperatures, if there's winter weather conditions, maybe like freezing rain or something. Those would be indicia of potentially hazardous condition. Now, there is a lot that can be said about the open and obvious doctrine. It has been considered many times by the courts, probably hundreds of times, and that review is ongoing. There is a case now before the Supreme Court, Michigan Supreme Court, that may impact how the open and obvious doctrine can be deployed in a case, but for now, it remains a viable defense if the facts warrant it, if the facts support it. Just stated simply, if a hazard, for the open and obvious, if a hazard would be apparent to a reasonable person upon ordinary inspection or observation, that would present an open and obvious defense to common law premises liability claims. Now, in order to avoid the open and obvious defense generally, and as it relates to ice and snow too, a plaintiff would have to prove that the condition has some special aspect. That means that a hazard creates in order to avoid the open and obvious defense generally, and as it relates to ice and snow too, a plaintiff has to prove that a condition has some special aspect. Special aspect. That means that a hazard that creates an unreasonable risk of harm, or that a condition was effectively unavoidable. As to an unreasonable risk of harm, the exact language from the case law is a condition that creates, quote, a uniquely high likelihood of harm or severity of harm if the risk is not avoided. And the classic example that the courts have given us is a 30-foot deep pit in the middle of a parking lot. That might be open and obvious, but the risk of severe harm is so significant that it would likely be found to create an unreasonable risk of harm, and so would be a special aspect, and the open and obvious doctrine could be avoided. Now, as to that second special aspect that I mentioned, effectively unavoidable, courts generally look at the reason for a person has to traverse an area, or if there were other paths available to that person, if there are other routes they could take. If there were, then the court would be more inclined to find that this special aspect did not apply. But if there is essentially only one available path for a person to take, and that person has to traverse that path in order to exit a building, proceed somehow on an essential route, a court could conclude that a hazard is effectively unavoidable, which means that the open and obvious defense would not be available. Now, these issues, open and obvious generally, unreasonable risk of harm, effectively unavoidable, they are fact dependent. And that means that it's going to depend greatly on the facts and circumstances on a case-by-case basis. So in the context of litigation, those facts have to be developed during the course of discovery. And to do that, we use photographs and diagrams and testimony and sometimes meteorological records and so forth to develop that record. The unreasonable risk of harm and effectively unavoidable and the open and obvious doctrine generally is fact dependent. All of them are. Now we're going to shift back into discussing the statutory duties. Everything I've talked about before were common law with regard to open and obvious. Back to the statutory duty. Remember that a landlord has these duties: a duty to keep the premises and all common areas fit for the intended use by the parties, to keep the premises in reasonable repair during the term of the lease, or comply, and has a duty to comply with the applicable health and safety laws of the state and of the local unit of government where the premises is located. You see the statutory site there. I think I mentioned it before, MCL 554.139. We're going to be coming back to those duties, but I thought this would be a good place just as a quick reminder. Some important areas to keep in mind for apartment complexes, especially as it relates to ice and snow. Those Michigan winters again. Parking lots and sidewalks in residential areas are common areas. Okay, fair enough. Accumulation of ice and snow on a parking lot or on a sidewalk does or can render the premises unfit for the intended use, which would be walking on it. And so a landlord would have a duty, a statutory duty under section 139(1)(a). The accumulation of ice and snow does not constitute a defect in the property. So the landlord would have no duty under MCL 554.139(1)(b). So just to restate that, the accumulation of ice and snow can render a common area unfit for its intended use, but that does not necessarily mean that it is rendered the property defective. Of course, if ice and snow causes damage to the property or causes some other damaged condition to occur, then the landlord might owe a duty to maintain the property in reasonable repair. And note, too, that there is a duty to comply with health and safety laws that apply to common areas. Sometimes we gloss over that, but it's important to keep that in mind as well. Sidewalks, driveways, and parking lots. We're going to talk about these. We're going to narrow these down, but we're going to start generally with the discussion about all three. Sidewalks, driveways, and parking lots. These are in almost every apartment complex. Whether an area is fit for its intended purpose and use under the Landlord Tenant Act, remember the statutory duties we've been talking about, this requires a determination of the intended use and purpose of that area. So sidewalks, as an example, that are going through an apartment complex are intended for pedestrians to use. So foot traffic and other types of pedestrian traffic, that's the intended use of sidewalks. Driveways are intended for pedestrian use and for parking vehicles, and parking lots are intended for parking vehicles and for pedestrians to be able to access their parked vehicles. So let's focus in a little bit on just driveways and parking lots. This can seem like hair splitting, but driveways that provide access to garages and residential units may be treated more like sidewalks than parking lots. But just because a person uses a driveway to access areas of the premises on foot does not mean that the area is more like a sidewalk or more akin to a sidewalk. And key to this is, in that circumstance, there has to be some evidence to support the claim that the intended use of a driveway was for pedestrian or foot traffic. So there has to be that factual development with regard to driveways and whether or not driveways are intended for pedestrian use. All right, more on parking lots. We're going to keep going on parking lots. A landlord does have a duty to provide reasonable access to parking spaces in a parking lot. This is a general rule. There's some authority out there that says that a landlord does not have a higher duty of care to a handicapped person to provide access to handicapped parking spaces. The duty is to provide reasonable access. That's the standard. And as far as ice and snow that accumulate between parked cars, that fact, and we've all experienced that condition, or those of us in Michigan or other snowy states in the wintertime, snow and ice between cars that have accumulated there does not render the parking lot unfit for its intended use. So cars parked side by side, snow accumulates between them. You obviously can't get at that with a snowplow or anything. That fact that there's all snow between cars does not render a parking lot unfit for its intended use. All right, enough about parking lots and driveways and sidewalks. A few items that are of special concern. What about insects, spiders, bed bugs, other bugs? Well, there's no duty to get rid of or guard against bugs under 139(1)(b), and that's the duty to maintain the premises in reasonable repair. So there's no statutory duty there. And also, a tenant has a duty to maintain the cleanliness of the parts of the premises that they occupy or control. And you see the statutory citation there that provides for that. What about pit bulls? Pit bulls, dogs, they have a bad reputation, pit bulls do. Well, I guess this would apply to any other breed of dog, but pit bulls especially. Liability, landlord liability attaches only if a landlord has actual knowledge of the dangerous propensities of the dog and still goes ahead and leases the premises to the dog owner. Now, in cases that I've handled, barking has not been enough to show a dangerous propensity. That's just an example that I've had personal experience with in cases that I've handled. Dogs bark, all dogs bark. That doesn't necessarily show a dangerous propensity. Well, what could show a dangerous propensity? Teeth baring and growling might show a dangerous propensity. Biting certainly does. If a landlord has knowledge of a dog's aggressive or dangerous propensities and leases the premises anyway to the landlord or to the tenant, that might trigger liability for the landlord. So it's important that you keep that in mind when people come to you to lease premises that have dogs. What about criminal activity? Well, a landlord does owe a duty to tenants and guests to take reasonable measures in response to ongoing crime that takes place on the premises in areas that are in the landlord's control. Now, reasonable measures. You can dream up all sorts of things that you can do as a landlord to try to deal with ongoing crime in the areas of your property that are under your control. But reasonable measures really means that the landlord has to call the police. If you call the police, that will generally be considered reasonable measures. When you call the police, you call 911, those calls are recorded. They're all recorded, so there'll be a documentation of your call. You call the police. You do that when you have these problems on your property. You do that every time that's reasonable measures. So all you need to really do is stay on top of it, call the police. What about condominiums? Landlord Tenant Act does not apply to condominium owners or co-owners. Condo associations do not owe a duty under the Landlord Tenant Act as to common areas because the common areas are not subject to a lease agreement. And it's really that simple. Truth in renting for residential leases. This is important because there are certain things that cannot be part of a residential rental agreement. A residential rental agreement may not include a provision or a clause that waives or changes, alters a remedy available to the parties if the premises is in a condition that violates the statutory duties, those duties we've talked about throughout this. Those duties are statutory, they cannot be waived or altered. Also, a residential rental agreement cannot contain a provision that exculpates, and that's a fancy word for just seeks to avoid liability for a lessor's failure to perform or negligent performance of a duty imposed by law. Those type of provisions are void as a matter of public policy, so that just means that they will not be enforced. Now, everything I've just said here applies to residential leases. Commercial leases, they are different. They're more like regular contracts. Commercial leases can include exculpatory clauses. They can include clauses that amount to liability shifting to tenants. You can require your tenants to name you as an additional insured. You can switch possession and control to tenants. Those type of contractual provisions that are in commercial leases are allowed under Michigan law. So those are some of the special considerations for landlords. Thank you for your attention here. I hope you found this overview helpful. I wish you all happy and successful renting.